Papa.
I request everyone please keep your microphones on mute.
Excuse me, Abeda.
Yeah, please tell me.
Myself, Ganesh, President of Svls Telangana. So,
Yeah, okay.
CVS Sharma is not able to join the meeting. So, can you please add him? Who's the host of this meeting?
Actually, Mr. Raghavendra is the host of this meeting.
Okay.
And
Let him know that CVS
yeah,
Sharma is not able to add. So,
okay.
uh, if there is any option, let Raghavendra add CVS Sharma to join the meeting.
Yeah, okay, okay. I will tell.
Okay.
Yeah, I think Sharma sir joined in the meet. Now it's my privilege to introduce today's respected guest speaker. We are honored to have CVSS Sharma Garu with us today. He's currently working as an advocate at High Court of Andhra Pradesh, and he completed his law graduation at Dr. Ambedkar Law College, Tirupati. And he is also a vice president of Sri Venkateshwara Legal Society. Today, he will give us on the important topic cases and judgment trading. We are truly grateful to have with us listening us today. Now, without taking much time, I request CVSS Sharma Garu to kindly take over session and enlighten us on topic case search and judgment reading.
Yes. Am I audible? Hello?
Hi, you are audible.
You're audible, sir.
Yes.
I
Thank you.
request
Thank you.
everyone to please keep your microphones on mute.
Firstly, I'm very much sorry to the team and all the members and all the interns. As of being my team's, my Microsoft Teams has not been working properly, and that is the reason I have joined late. And before the starting session, let me tell you the main topic that is which we are going to discuss right now. And the topic is case law search and judgment writing. So before we just intro or begin our topic, let us decode the topic case law search and judgment writing. So probably when we have joined our law schools or etc., we'll be studying more particularly on reading acts like bare acts or like the statutes or probably the law books. But very soon after joining, or for example in our college, always part C will be like we have leave the option for judgments. Like for example, a case. For example, the case law illustration will be there when we need to write judgments of them. So, but whenever we are going to practice or we have started practice, the more importance of reading judgment and citing judgment will become or play a vital role in our practice. So, it is not a great academician that if someone asks like what is section so and so or what is the article of so and so, it is not that much great or that much wide to respect. Am I audible?
Yeah, sir.
Yeah, it is not become that much great because when we practice, the biggest question will arise when we are not reading the section, but what the citing or what the citation that we are giving to the judge in the, or in the court, that becomes that much great. Because, and I'm here not to teach you the sections or case laws or whatever, but we are learning a new skill right now because that skill which actually makes important in research and drafting and conveyancing the court. The main part in the court system or on our Indian judiciary is conveyancing. How the advocate is conveyancing the court. And conveyancing will become easy part when we cite judgments. Because when we are citing a judgment, it has been delivered either by the apex court or any other high court or even in the lower courts where a district court case will be sometimes can be taken for example in the municipal courts like junior civil judges or principal courts, but it is the president that actually have been given importance to follow the apex courts. Can I request Raghavendra, are you there? Hello?
Yes, sir.
Sir,
Please tell
please.
me.
Is Raghu there? Because Raghu has prepared some PPT. Can we share in
Sir,
the screen?
I will share a screen share. I will.
Yeah. If you just
Wait, wait.
yeah, in the meantime we can discuss because my topic is on case law search and judgment reading. So mine particularly the law that we are actually speaking right now or the judgments which we are discussed will be discussing right now will not be there in books. We can confidently say because all the sections how the court will be interpreting it, how the intention of the legislative makers or intention of the lawmakers have been interpreted that section will be on judgments. Now the question starts like which judgment should we follow and what is the correct or appropriate important portion in the judgments and how do we uh, read out or example to me memorize the very big judgments. This is my topic right now. If we before we delving into the topic, there are some important words. It sometimes will be reading that in jurisprudence, interpretation of statutes, and the common law aspects, because that Latin words or that portion will definitely reach us to understand how the judgment will be placed, whether to read or either to write or either to cite. Because the very first important thing in judgment is obiter dicta, stare decisis, precedent, and ratio decidendi, and sub silentio, parincarum, and difference. All these words, all this terminology has been there whenever we are citing judgments and whenever we are reading judgments. So, whenever we are reading judgments, we will try to read the operative portion of the judgment. That is why the judgment has been delivered. In fact, there will be a question into our minds when we are reading judgment. It will be starting with the factual aspects of the case, and it will be going on the pervasive findings, and on the next the concurrent findings, and after that the legal objective of the case and the various submissions of legal submission from various courts, because you will be finding in the judgment of other high courts or apex of Supreme Court judgments, and after that the conclusion part or the court's decision will be there at the last ending. So this is the exact provision of judgment writing. And now whenever we are reading judgments, we'll try to think that why the judgment has been delivered, on which aspect and upon which principle. The main principle of giving that judgment is ratio decidendi, reason behind the judgment. Simply because when we take some example, because in whenever we read science like chemistry or physics, we'll be remembering some which examples either in Thomson model of atom or Rutherford, etc. Even try to bring one example we can take is a mango example I can cite. In mango there will be a seed. The seed which holds the whole mango is the main core of it, and that is ratio decidendi. And the pulp or the flesh, all these which after the seed the flesh will be there, that some part, and that is obiter dicta. And all the skin of the mango or whatever we see, the outer layer, and that is the stare decisis, the subsilentio, the difference, parencherum, operative portion, all these. So whenever we just Raghu, is it working or not? Hello.
No, it's working. Wait, wait.
So if you just screen share it, probably they will be seeing the terms, and
Okay,
I
okay.
can get the grasp of that subject. Is it working? Okay, anyway, let us continue. I think so, it is working. Yeah. Yeah, before Raghu shares you the screen sharing, some more will be discussing on the topic ratio decidendi, that is precedent, stare decisis, and obiter dicta, and subsilentio, and parincarum, and difference, distinguish. So all these 7 terms, before whenever we look into judgment, remember these 7 terms in your mind. The judgment is actually the application of mind, of the intention of the law, because whenever two interpretations have been given to the court, or two submissions have been made, or any rival submission have been made, it is a duty of the court to deliver not only justice but the exact verbatim, that why they have given that judgment, and why the court comes into the steps of the parties and giving that judgment, or the submissions, that why they are defending that this is the correct principle to follow. And that will be by taking something in examples, in illustrations, by citing over the precedents or the judgments of the highest court, that is apex court or supreme court, or various high courts, will draw into some conclusion. That is the better conclusion, we say, and that is delivered in the form of judgment. Now the question arises, suppose for example I have cited the Telangana High Court judgment, and someone, my opposite, my counsel, opponent counsel, has been cited the Bombay High Court judgment. Now which judgment should be the court will be relying upon, or which part they will be taking? Since I practice in AP High Court, the first they will be considering is the apex court, that is Supreme Court judgment. It should be binding on all the high courts and all the courts in India, the jurisdiction. And next step is whichever high court, either in division bench or in a judgment of the respected jurisdictional high court, that judgment will be upheld first. And then the various other high court judgment will be taken into part of our consideration. Now, the screen sharing, I think, is everyone aware of seeing the screen share which is shared by my my learned friend Raghu?
Sir,
In law language, we will be saying, are everyone witnessing this screen sharing?
Yes,
Yeah,
sir.
Raghu, just change the next slide. I hope everyone is seeing the topic. Yeah, now why case law is the backbone of Indian legal system? Since India follows common law system, yes. Let us take some more introduction of this, because how these judgments or how these aspects came into our law books is because of common law. Of course, we'll be hearing this one word from many aspects, like yes, we are following, are we still colonialized, or are we still following the British rules, or etc. Because one might be in understanding way that all these aspects are derived from common law. And why the common law is that much wider? Because it is not written exactly. That is why it is great. If you go and search in like United Kingdom, there is no written constitution for United Kingdom, unlike us, our American constitution. They have been developing since in era on only by way of common law, and that common law is based upon judgments. Like for example, you might have seen, what is the doctrine of basic structure, if someone asks, or like what is some doctrines or something that has been evolved from the court, is actually based on common law. There will be like for a moment all these and there will be one interpretation also, like for example, when center and judiciary becomes like a legislative power is great or judicial power is great, because the law making power is actually on the legislative part but not on the judiciary side. We are actually the guardian or watchdog of our constitution, and when we start interpreting the law, the main core issue has been aroused to judiciary, and that doubts that latches in between those sections, from one section to another section while interpreting, some latches are there to connectivity, and that connection are made in answers by the judgments called doctrines. And that doctrines which we cite are more pervasive on it, giving more extra clarity on that wider aspect of section or wider aspect of legal submission. That is on the part of the precedents. When we follow the precedents and adopt and give the judgment, that is the correct judgment that we will be following on many ways. Now, for example, if you take whenever that judgment has been given, there are the law that developed through statutes, that is, of course, the legislation and judicial interpretation. Like now we discussed the doctrines, all the aspects that has been come into the court that will be submitted through the judgment. The answer is simply whenever some questions will be asked, we'll be giving one a good answer. Now we are taking which is the best answer, because there will be a hunt. In my opinion, one will be the best answer of my knowledge, and some other says something. Now, when we compare all these members, which will be the best or appropriate, suitable way, and that will be taking into adopting, and will be relying on that much core of that particular issue. Then, under Article 141 of the Constitution of India, that the law declared by the Supreme Court, that is actually the apex court, shall be binding on all the courts. Just now we have discussed within the territory of India. This makes law as primary source of law and merely pervasive material. Now, by which article, if someone asks like you that yes, you are relying, why we are following the Supreme Court judgments, only Supreme Court judgments that are binding on us? Because if you take anything to the court, when you are practicing, it is not about the only issue of, because when the judge will not ask you to read out this particular section like what we are doing and what we are reading in our classrooms of law course. It is the judge that they will ask you on which judgment you are relying upon. Why you have come to that conclusion? How you are saying that yes, your case is not pervasive or concurrent. Your case is correct. Your intention is correct. That you want this court. You have come to approach this court on relying of what? The principle or which, that what made you to come to reach this court and knock the door of justice. So all these actually aspects, why do we confirm that only apex judgments are will be citing over all the territory of India, is actually based on this article 141, that gives the power that the apex court judgment is a final. Like in a Latin way, we say lex suprema nex. The law should be always great. But my question is, which law should be great? Because there are two kinds of laws. One is just law, another is unjust law. You see, when we have taken initially freedom from British or colonial era, there are some unjust laws that have been followed by British or imposed by Britishers on our Indians. That is the reason Gandhiji march to salt law was came. Dandi march has been happened. We are not against of such laws. There are some laws which are actually very difficult to say. Like for example, in our modern law, UAPA Act is there, Unlawful Activity Prevention Act. Previously it was called as POTA, and that much before it was called TADA. All these actually comes under one aspect, that is to eradicate terrorism or any such activity, that is called unlawful activities. Now, by using that UAPA, does the government will say or any arrest a person without any issuing notice? 41A notice have been not, all the procedures have been not been followed in our country. So that the subject is mainly relying that whether which law should be upheld, because something wrong going to happen either in abuse of process of law or by not by following the due procedure of law, which law should be upheld. So that all the things have been discussed in the form of judgments. When interpretation comes, the judgments will play a vital role to understand the main endogamy of law, main practical approach of the courts, and how the justice will be given or attributed to the society are actually made by the decisions in the factual aspects of the law course. Now we can say how the law will be implementing on the factual aspects of the judgment. See, for me, I understand in such a way. It is my opinion. For my sake, I am just saying. It is not that the law is always great. It is because of the facts. It is because of the main factual aspect that we are using this law as a tool to get the justice. Now, if we take, for example, one thing, uh, anything like murder have been happened in society, or like anything, for example, a criminal case has been filed. See, in criminal case, we'll following the beyond reasonable doubt concept, and civil case will follow preponderance. So all these two are very wide aspects when the court comes into picture. Now there will be a filing of writ petition in the High Court about the civil nature of the case. So all these are actually jurisdictional errors that have been still following in our High Courts and Apex Court. So the main aspect comes into picture that why we need to follow the Apex Court judgments, because when the reaching of the judgment reaches to Apex Court, it will be having a broader aspect on that law topic, and broader research, broader interpretation will be taken on law consigns. So that will be binding on every other part of the High Courts or every part in the nook and corner of our Indian judiciary. So that is the reason when Apex Court have made as a decision and come to into conclusion, we need to follow the Apex Court judgments. And sometimes it may take in a wrong way, because after all, many years have been passed. Previously, the right to privacy has not been given. Now, and by that, by the virtue or by the blessings of case, Justice case, Puttaswamy case has been given again, restored the justice by giving legal aspects of having that right to privacy. So after many years, that right have been still even in question sometimes, even I say still not been properly implementing in the society of right to privacy concept. So if we see and go on these issues, it is very difficult to say that upon which aspect or which way the court is looking or court is thinking. So how do we decode what is the intention of the court on giving such judgment? Why the judgment have been delivered by the Apex Court or various high courts, and how they are relying, how they are giving. There are two concepts. One is obiter dicta, and the second is ratio decidendi. Now, Raghu, can you share the third slide?
Okay, Anna, okay.
So, when we come to the picture of the concept called ratio decidendi, the reason behind the judgment, why the court come into conclusion, and how the court come into conclusion, and why this judgment have been passed. The main principle of the that tribal submissions that have been made will be discussed in the ratio decidendi part. If you take an example of any judgment, every judgment contains the ratio decidendi part, the reason behind the judgment, why the judgment has been delivered. It is not very simple reasons that the judgment will become into a conclusion part, or the court comes into conclusion and delivers the judgment. It is not that much easy. We'll be hearing upon one submission made by the appellants or petitioners and another submissions made by the respondents. And all these submissions that have been reached to the court, and then the court applies its mind, and then the interpretation starts. And after the completion of our interpretations, we'll be citing judgments on our contention. And when such submissions have been made to the court, whether that judgment is right or not, whether that judgment is applicable to
Sharma, ma'am.
Hello?
Are you able to see the slides?
No, actually, there are, I think Raghu is sharing the slides. That is the reason I'm discussing.
Just a second. I'll be sharing the slides. Just a second.
Okay. So, I think, yeah. Which?
Are you able to see the slides now?
I think now everyone are witnessing. All of you are witnessing, right? The slide share. Yes, yes. They are actually saying yes, I think.
Can I move to the next slide?
Yeah, next slide, please. So actually, this is a constitutional foundation. I think the article 141, that why we are following the apex court decisions is actually because of ratio decidendi is binding. Not every observation becomes law. A larger bench overrides a smaller bench. Yes, I think we need to discuss this topic. Before we going to discuss this topic, let us understand what is larger bench, what is bench, what is division bench, what is king's bench, what is constitutional bench, and what makes this bench even great maker, or what is more beyond greater than the judgment that has been passed by the previous judgments or single judgment. Now if we focus, that comes into the step-by-step procedure. The first judgment will be given in municipal court. That is the place where the trials will be started. That is, we can say in commonly as lower courts, but for me, they are the backbone of the judiciary. Without lower courts, there will be no appeal further, either to survive in High Court or either in Supreme Court. I mean the case. So initially, on civil or criminal, the lower courts are the first approach to get the judgment. Then the judgments will be going, if any error made in the judgment or we found, it is a general procedure to go to appeal to the higher bench. Then the district court will be the jurisdiction, and district court delivers some judgment. Now the any again error, a mistake has been committed, or they want to go to appeal on some aspect. Now the court is much higher, that is the High Court will approach the High Court, and now the aspect comes more tight, and still the judgment has been delivered, will approach the division bench. And in that division bench, certain principle or law point that has been to be yet clarified, that division bench will make reference to sit to the third bench, that is three bench, constitute of three bench judges. And if still they are not able to differ, or any deferred judgment will come into picture, that three bench will be constitution upon five bench, that is constitutional bench. And still, if we sit, or if we there is any laguna or any latches, that five bench reference will be made to seven bench, that is larger bench. And that seven bench will make again at most last stage is the 13 bench, the largest bench in India that took part by delivering the judgment is Keshwananda Bharati case. And that is the reason it is great. It has become a landmark judgment. Upon all these landmark judgments, we say, or we have been citing, we have been reading, the judgment which have been delivered by only the division bench is great, because all these three benches or five benches or seven bench or even the 13 bench, they will not give the judgment. They will clarify on legal submissions only. And that is the greatness, that these judgments, all these have one thing in common, because whenever we take these benches, it will be only on odd numbers only. As to put, when we count on which the judgment differs, the highest count will be on odd number or either in even number. Because if we take five opinions of judges, there is actually a chance to get majority, that is either 3:2 or 4:1. So now, why always larger bench actually relies upon the lower bench is the decision that has been taken. Previously, jury is there before entering, comes into picture of giving judgment. The judge will ask the jury opinion. There will be some members in the court who will be sitting and watching the case. Now the jury system, of course, is not there, but earlier it was there. Jury, they'll make and they come into some conclusions and they give their submissions on that particular case to the judge, and then the judge, he will write the judgment because of jury decision, majority of the thing decision, that the court will comes into picture. And of course, it is very well known fact that sometimes justice become inferior because our law is superior. I must say that the justice should not decide on majority. But of course, the majority concept is always great, either in form of democracy or by giving judgments or delivering judgments, or when we are following, the majority concept has been taken by the judiciary. And for me, justice might sometimes not be delivered on majority basis. Sometimes it is based on the the law or the intention of the law or justice. The core is to give justice. That's it. Now, I think Ganesh, can we move on to the next slide, please?
Yeah, sorry for interrupting you in between. I
Yeah,
kindly request all of you to please turn on your cameras if possible.
yeah.
I
The
request intern to kindly. Yeah, sir, please tell.
Yeah, no, I'm just saying that your announcement. I'm repeating your announcement. So all the
Yeah, sure.
participants or all the interns who have joined this session, kindly our request from the team is to uh, on switch on the only video, not audio, because it will be get disturbed by others. Kindly turn your video only. Yes, I think some of them have started. Yeah, now we'll be continuing on the topic, that is the doctrine of precedent. So we have these doctrines. Previously, we might have been reading these doctrines, but how this doctrine system has been come into picture, how the doctrines are made, why there is a necessity to read the doctrine, and why the courts have been using these words. When we look into this aspect, the main lawmaking body is actually vested by legislature. So judicial has no role or no power itself to make the law or to amend the law. That the system we are following through separation of powers. But American system is something different. They follow checks and balances. That is totally contrast to the separation of powers. But in India, we are sometimes following the checks and balances, and we are also in the main core of separation of powers. Now, when we see this aspect, the lawmaking authority is actually vested on legislature. But if we see these doctrines, our doctrines comes under law. So other courts are having power to make these doctrines, and that doctrines can be usage or can be the doctrines be implemented in the lawmaking body, or can that doctrine is authenticate to in the usage of law. So that question actually comes into picture. These doctrines made all of us possible to understand and approach the intention of the legislative core makers. Of course, not only that, but main elaboratedly, they have given their findings of the judgments. And based on the findings of the judgment, they have made these doctrines so that the lower courts or any such aspect on the pervasive question of that particular judgment arises, this doctrine will be in usage. Doctrine of ultra-virus, doctrine of basic structure, all these doctrines are actually made by the judiciary, that is the courts. Judiciary alone is not responsible. In the judiciary, courts are one part in judiciary. Simply we can say the courts are tribute to judiciary. Judiciary is a wider concept, and the courts are one of the part in judiciary. It is not whole judiciary itself. The courts are one part of judiciary, and now courts are tribute to judiciary by making these judgments that rely on all of us, because judgments are also become law in one aspect. Because someone will be asking you what the definition of law. Someone will be saying, or any will say that the best example of law is all those rules and regulations, or simply we can say that have been to maintain order and peace, etc. That definition part will be there in our books, and that the same definition part itself, the judgments are also comes into picture, or what we are reading in law. So The doctrine of precedent is based on stare decisis. That is the standing of a decision on what standing the judgment is has been there. That is binding on precedent. Now, pervasive precedent, overruled, distinguished, per incurrum. All these 5 concepts. Another concept is also there. The 6th one, kindly make note of it. That is called sub silentio. The first one is binding precedent. It is always the apex court, the Supreme Court decision that we all must follow bluntly and blindly. Either it is in good or bad or anything. We should not deviate from one thing. That if that particular concept and the same level of concept or approach have been taken up in apex court, Supreme Court, we shall follow the same rule that has been interpreted on that topic or on that aspect will be following or upheld by the lower courts or higher courts. Right? Such decision has been made by the Supreme Court on that particular aspect. Now, pervasive precedent. There are 2 concepts whenever one judgment has been delivered. If lower court has been delivered on the aspect, one aspect, and that has been actually upheld by the district court, and now the appeal has been filed in high court, since the 2 courts, that is lower court and the district court, have been made on findings that it is not, they gave favor to one appellants. It is called concurrent findings, because there are 2 types of findings when we read the judgment: concurrent findings and pervasive findings. And sometimes there will be saying some different aspects will be there in the court comes into picture, of whenever the courts looks into the precedents and follow the citation and rely upon the case. One such finding is pervasive precedent. The pervasive precedent may particularly focus on either one judgment has been deferred and again judgment that has been reverted back and made into some other conclusion, and now again the appeal has been filed. And the third concept is overruled. I think this was very famous concept. Whenever we'll see movies or cinemas or like pictures of our own law movies, objection or overruled, these terms will be there in the movie. So overruled means, of course, definitely in one word answer, yes, the contention is not correct. Then the court will be not following that. Now distinguished. Distinguished means difference. Like for example, when I have my case is, let us take one illustration, because without illustration it is not rightly to say that we'll be understanding better. Now, for example, Sharma is going somewhere. Suddenly, police asks on one thing, or about either murder investigation or any theft case, and it is pretended that I am the suspect. I became a victim, suspect, accused on their contention, police contention. Then I need to approach to high court or district court to file or to get anticipatory bail. Now, whenever such anticipatory bail has been filed by the accused, it is not always such a thing that there will be a term will be listening. Jail is the rule, bail is the exception. Or bail is the rule, jail is the exception. These both concepts, when we search upon these bail issues, it is always discretion part. It is always not mandatory. And when we search upon these issues, the apex court will be decided on anticipatory bails or bail rules. Arnesh Kumar judgment is there. To follow Supreme Court guidelines have been made. POSH Act was there. It is actually not only interpreted, the law itself, guidelines have been made by judiciary itself. We actually step into the shoes of legislative makers or the legislative body. And then these acts are made. So when such law has been given the form of judgment, and now the judgment that I am reading is not actually on my contention, my whole factual matrix. See, we will stick on only to those judgments which rely on my factual aspects, not other factual aspects. Like for example, Keshwananda Bharati case, we all will be knowing. The doctrine of basic structure is have been given. On that case, many concepts have been delivered. But that's all the concepts have been discussed. No, certainly not. Only comes into one particular way at the conclusion. But that particular conclusion is relying my contention or not is important. And now, if we say, for example, we can randomly pick Article 21. Now, in that Article 21, there are some thousands of case laws. We can't say that each case law is the same because they are same on Article 21 itself. No, it is not. Each case itself will differ from one case to another case. And there are such like there are thousands landmark judgments are there only in Article 21 itself. And now simply because Article 21, my personal liberty has been used, can I cite the passport issue Maneka Gandhi case because it is on Article 21? No, because the law 21, it is only the law that I have been using, not my factual aspect. That because my factual aspect will become different to another factual aspect, still the article is same. So I cannot cite simply because I have been used Article 21. I can only cite the judgment. Only cite because my aspect and my factual matrix is same. And when the same in nature, then only that judgment will be binding. Otherwise, it is not. That is distinguished. Now, parent curiam. The word parencurium is simply, it is called the mistake on law side. And there will be another interpretation. Ignorantia juris non excusat. Ignorance of law cannot be executed. But what if the court committed a mistake on legal side? What if the court, simply my question, one biggest question is the judge have been delivered the judgment or the court is giving the judgment? The one question which surrounding or move to one aspect is, does the court gives the judgment or the judge gives the judgment? Kindly, I put this question. The answers can be given on the chat box so that we'll discuss and pause this question to later while ending the session. So this parencurium means the legal mistake that has been actually committed by the court. Like for example, there is a case called if the precedent is like a rule book, if rule applies but your situation is different, it is distinguished. If the rule book itself have been forgotten that why the rule has been made, then it is called parencurium. And if the issue was not consciously decided, then it is called sub silentio. And kindly the sixth one, kindly please make a note of the another word, sub silentio. Sometimes whenever the judgment has been delivered by the judge, there will be not focused on certain topics or certain issues. Even though that comes into wordings of the judgment, that topic will not further enhanced or given clarity on that topic. That is, we can say the law is silent on such topic or the judgment is silent on such aspect. That means which the judgment have not clearly given clarity or clarification on the topic. That is sub silentio. Even that operative portion also or that decision also not binding on the judgments on the various high courts or the aspects which we are going to cite. So all these are actually the concepts upon which judgment would we be citing and what judgment will make us better to uphold our contention. That is the main role is on conveyancing. So what is the better way to conveyance the court by relying on the judgments? That what we are citing. So when one topic is on silent or not, the apex court or various high court have been not clearly defined or clarified or given such enhancement on that issue, then that judgment will not binding on us. That is sub silentio. When one judgment have aspect and my contention factual aspect is totally different, that is distinguished. When I cited judgment that is totally contrast, that is overruled. When my findings are different from another court to other court, that is pervasive. When the judgment actually decided by the apex court on the same nature, same contention, same aspect, same topic, in the same way, it is called binding precedent. Ganesh, kindly shall we move to the next slide? Now, how courts actually use these precedents and how they comes into conclusion of the picture of the judgment. The reality is judges read facts carefully, or even the judges will not be reading. We are there, the advocates, we are the officers of the court. It is our duty to reach the facts to the court. If facts differ, see, our case is different. The aspect of the judgment which I have been cited is different. Then that is both are different. That different word is distinguished. If legal principle changes, the whole contention becomes contrary. That is called overruled. And the example which have been given there, Ganesh, can we move to the next slide, please? Yeah, I think, and the two other concepts that we have missed is when laws such have been silent or not able to give clarity on that topic, that is called sub-silentio. When the rule book itself, that is, for example, apex court have been given one judgment on the particular topic, and the high court have made another judgment contrary against of not following the apex court judgment, then that is perincarium, the legal mistake that have been committed, the error in the judgment. And now the reading of judgment will be constrained to all these concepts. Now we'll be moving where to search case law, because after we'll be knowing the judgments, how to get the judgments is also important for us. Because since these in modern era we are developing these chat GPTs, all these AI tools, Perplexity is there, Meta another, and all these AI is actually generating not which are actually authentic. Because if we type one case law in those AI, it will automatically rely and change the whole contention of the circumvent of the sentencing itself. So it is not good to authenticate those judgments. We can take into example and we shall read the exact verbatim. Verbatim means the same lines or the para that has been written in the judgment. That part only is relevant. And also it is too important whenever the judgment have been made or delivered, when we are reading the judgment, it is the operative portion that is which is important or plays a vital role when we are submitting the citing of the judgment, and not the submissions by the learned counsel for appellants or petitioners or learned counsel for the respondent. All these submissions are not relying upon the citing of the judgment. The only conclusive part, which means not in conclusion, the operative portion, that is the ratio decidendi part, is important. Only that principle plays a major role when we submit those citations with the judgments copy to the court. It is not all the submissions. That is pervasive. Yes.
Can you please give the example that the case we have dealt with RTC?
Yeah, there is one such famous case where I was actually researching upon one topic, that is an accident has been occurred near to the bus stand turning. One citizen fell down in the rear wheel of the bus, that is the last tire, the bottom tire of the bus. It is the finding. The court actually initially asked me how the accident occurred, because it is the duty of the prosecution to find out how the accident occurred and why the RTC driver is liable upon such that it was something called in the intention of the murder or intention of the rash of negligent act of the driver, that due to which the rash negligent the accident has been occurred. The findings of the court is vaster on this subject. When I am dealing with this exact case, the judge asked me to submit some citations on particular topic, on particular aspect. When the scope becomes less, that but we are following certain rules. Whenever such pedestrian is walking and suddenly an accident occurred, the accident or collision occurs in the front body part of the bus. Then if the front body of the part hits the man, the tire will be moving on the body of the victim, and then he reaches to the back tire. Now in our case, it is not like that. There are no tire marks on the body, but he was on the back side of the wheel. So the finding of the bench is, how did he reach the back tire or back wheel without hitting on the front side? So it means that the pedestrian or the walking person might have itself contributed the act. Then such concept have been called contributory negligence. It does not come under rash and negligent part of the driver, because whenever rash and negligent part of the driver comes, the driver will be convicted because of his rash and negligent act. Now, here in our case, someone while boarding the train or boarding the bus might have the chance to fall down from the podium or from the steps that they are entering into the bus. So there are still chances that it is not always the rash and negligent or the mistake of the driver. It might be sometimes the mistakes of the person that comes under self-incriminatory case. So on proving such that case, my case was actually followed on concurrent findings. That is, lower court, that is municipal court, also given conviction to my client, and the district court also given conviction to my client. Now I have filed appeal in this high court that the driver is not done any mistake, because he was followed the proper law. He has been following with due care driving the bus. It was not on rash and negligent act, because we know how the accident occurred. He comes in a rear wheel, back tire of the wheel. So the judge, when we are citing these arguments, the judge asked me to submit citations. That is there any rule if someone is pedestrian who is not on pedestrian path crossing the road? For example, in highways, most of the highways places will be not having the zebra crossing, but still people use to reach from one side to other side. Whether accident occurred in that path is the mistake of the bus driver or the mistake of the victim itself, or self, that is comes under self-incriminatory case or negligent, rash and negligent on part of the driver. That question has been arised, and now it is my duty to uphold my contention, that to say that yes, I am right. I am not the apex court given that the rash and negligent act comes only into picture when the due negligence have been not been followed, or when due care has been followed, not on negligent rash or rash and negligent act has been followed. Because when due care has been followed, it is always to maintain a good speed at national highways or highway roads. And whenever we are going on highway roads, the maximum speed will be definitely below the 80 or above the 60. So at that time, if we use sudden brakes, it is highly giving disturbance to the 60 passengers, and that too the path, that is, there will be no pathway on the highways, national highways or state highways. There will be no zebra crossing. Only certain places where the junction will be there, or where the four roadway junction or sometimes crossroads will be there. That place only will be used as pathway, that is zebra crossing. But here the victim has been crossed the road not on the zebra crossing. So if we cross it where the pedestrian have been crossed not on the zebra crossing, or where he was not supposed to cross the road, and suddenly an accident occurred, either it is the mistake of the driver or it is a part of the victim, whether he will get any compensation or the driver gets conviction or not. So in this case, the lower court given conviction to my client and district court given conviction to my client. Now by filing appeal and by citing the judgment of this aspect, on this particular aspect, the scope of now aspect factual matrix become very much limited. That whether the pedestrian can cross the road in a zebra crossing or which the place where there is no zebra crossing. So that particular aspect has been delivered in one judgment by apex court, because he will be not supposed to cross on that highways or state highways where there is no zebra crossing. So that by relying on that decision, the conviction has been set aside, where now the driver has been given full sanctity that yes, it was not comes under rash and negligent act. So all these are such judgments that when we cite, when the aspect and concept and the nature of the case is also same, that judgments will be bind on us, not every judgment. But before we comes into this reading part of judgment, firstly we need to get the source of the judgment. Like for example, when we are submitting the judgment, the source is very much important. We cannot submit from Indian Kanun. They will not, the courts will not expect sometimes, because the source is should be authenticated. Sometimes there will be interchange of lines, or there will be missing portion of the judgments. It is always to submit to the court an authenticate judgment only. That is where we'll get from SCC, Manupatra or lawsuit. Sometimes these are a bit costly nowadays. For example, the sources when we are getting these judgment either by High Court website or by Apex Court website or by SCC citation or by ALT or by ALD or by LTJ or by Manupatra or by lawsuit. These are very much important. We will get where the place where the judgments, the copy will be authenticated. No, but we can cite on ChatGPT, on Meta, or whatever the AI tool to get the correct citation. But mostly, in sometimes the ChatGPT or Perplexity or whatever the AI will not definitely give the correct citation. So we need to recheck that citation and get from that citation through SCC or lawsuit or Manupatra or etc. to get the authenticity of judgment that we are going to cite or we are going to submit into the court. So all these are platforms to get the authenticate judgments. Now, the advanced research type also has been given that the paid platforms which are SCC Online, Manupatra, Westlaw, etc. and free platforms are Indian Kanun, Supreme Court website, of course High Court portals. So other two are actually binding. The Supreme Court website and High Court portals, the judgments will be getting are actually authenticated. Now, Ganesh, can we move on to the next slide?
Yes, yes.
The real courtroom strategy. And suppose we argue it is adverse possession case, the leading case will be so and so. If we only say adverse possession is allowed, so this will be the example. We can have a better example like how the courtroom strategy has been followed when it is the duty to take the citations. I think many of you know the exact elaboration of the citation. If we follow SCC, it will be always the year that comes first, then the volume, then it is the publisher SCC, ALD, ALT or any other thing, then comes under page number. So this is the exact form of the citation, and which citation comes with the name, it becomes a case law. When that becomes a case law with all those important topic on head note on the head side part, at the main first part, and then continued by whole the judgment or findings of the court, then we submit those citations to the court. At what stage is important? Suppose I am in High Court practicing in one case, and now the initial start will be giving introduction to the case, to our case. That for example, the main prayer, what we are saying or what we are relaying, what I need seeking relief from the court, I will be starting from that aspect. And then this is actually the procedure where the High Courts start. For example, main contention of the why you knock at the door of a high court will be saying at the first stage. Then the opponent counsel will be saying his version. And to prove my version, I need to submit these citations to prove my case that yes, there is an error while looking in this aspect, in this factual case. Then I will be submitting my citations in the form of judgments to rely to the court or to submit to the court or to have a look on what the right way that have been followed previously when such contention have been made into courts. And that is a strategy where these case laws have been made. Because when if you don't follow such precedents, it will become much helper and easier way to come to the conclusion of that particular topic and decide the case. Whenever we submit such precedents or such submissions or one such citations to the court, it will become easier and it will aid to us to come into conclusion that supports our contention. So that is the reason it is necessary to submit the citations or correct form of judgments on correct aspect, which is same in nature like to us, which is in same context, which the principle have been followed in the same way where my right has been deprived. Now, next slide. So the structure of the judgment. So whenever a judgment has been delivered, it is always by initially started by cause title. The cause title simply means it is not the great or something that it is not that much thing. Like the cause title will be actually given by the petitioner counsel. That is, who is the petitioner? The first will be upon the name will be printed the petitioners and then the respondents. And then at the first start itself, the jurisdiction of the court will be on the top of the judgment. That whole put together called the cause title. That is the jurisdiction of the court and the writ petition number that or the number of the particular case. Because why the number have been given is to find it easier. Because bunch of cases will be filing in courts. I know you will be a realistic example. Today, each and every one will be saying, if any right they have been deprived, I will see you in court. So we are almost every aspect. There are a number of cases that are still pending nowadays in courts. I think even the recent case that the NCRT have been given about the delay in justice, and now still itself is questionable in Supreme Court, because the judiciary is actually we are need to proud on some aspects, but still there are pending cases. So if we give this cost title and some number, it will be easier way to get the number and the case form whenever we cite. And that is the reason the number of that particular case will be given. And then the petitioner name, and then the respondents who are there, and then what under the writ or on what form this case has been filed, and then the bench composition. Sometimes single judge will be present, sometimes division, the quorum. Since we can also use the another term, bench composition, also called quorum, CORAM. How many judges are there, are delivering those judgment or not? In writ appeal, it will be decided by two judges. So etc. All these, that is, will be on bench composition. Then the date, yeah, of course, the date will be there. Then the facts. Initially, the judgment, every judgment will be starting. The initial position will be on facts. That I always say, it is not the law that is important. It is because of the facts that you are choosing that law as a tool to get justice. So based on your facts only, the law will be decided whether that law is applicable to your facts or not. Take the ingredients of a murder: preparation, commitment, action. All these are the ingredients. If these ingredients only fulfilled, then the murder section will be applied. If the ingredients itself is not fulfilled based on our facts, then the law itself is not applied. So based on our factual matrix only, the law will be applied to get the justice. So it is the facts that are always that great, and you need to remember. So we'll be writing on facts, and then the issues will be framed based on the facts. whether you have deprived some right, or you have a legal mistake, or where your right have been questioned, or where certain procedure has been not followed, that right will be framed in issues, and the submissions of the petitioner will be taken, and then the submissions of the respondent will be taken, and then the findings of the court will be arised by seeing the path of the submissions of the petitioner counsel and the way that the respondent counsel that have been gave reply to that questions of the petitioner counsel. Then the findings of the court comes into picture by seeing both the versions, by following both the principles of natural justice, and then the ratio decidendi will be forming, then the final order will be output. In between, one thing that we have missed is interim order. Whenever appeal has been arised, the court will give firstly the interim order, because sometimes the relief will not be given fully. It is given in the form of interim order, so that certain damage will not be proceeded from initial time itself, will be curtailing the damage. That is the reason. Ganesh, next slide, please. And how to identify ratio decidendi? Now, this question is important for us while reading the judgment, because there will be 1,000 pages. Some judgments will be there. Some a book you can make print to read the whole judgments itself. If we read Keshwananda Bharati case, it itself is a book. It is not judgment. I say it itself is a book. So we cannot read patiently all those from word to word, all those from exact facts to facts, all those where the unnecessary findings of the court, where our contention is not relied. So the questions are, what legal question was decided? Yes, it is very much important to decide that ratio decidendi of the judgment. We always must look into picture based on our factual context only, whether that contextual aspect has been discussed in the judgment or not is important. Then, what reasoning was necessary for decision? How the court comes into that reasoning, or comes into by those findings which are actually on my aspect or not. How the court comes into the picture of or the conclusion, where the this judgment has been delivered either purely relying on my factual, or upon which findings the court given the conclusion part. Now, what principle would change the result of if removed? See, if with this take a look into brief picture of the judgment, any judgment, there will be operative portion. One last in the bottom of the judgment, you will find the operative portion of the judgment. And before that operative portion of the judgment of the exact above, there will be legal submissions or findings or the reasoning of the court why that operative portion has been delivered. The court generally comes into a picture not by only duly following the petitioner's arguments, or not by only upholding the respondent counsel objection, but it is always comes into picture by only on the reasoning, or by form of various high court judgments, or the findings of the court in the interpretation. That particular scope and limitation of that particular concept will be decided on legal submissions. Then the operative portion will comes into picture of the judgment. The operative portion is important because it is the heart and soul of the judgment. Only that particular judgment operate, that para, relevant para is important to us. Whenever we cite those, only that particular verbatim para only will be taking reference to the court. Not all the aspects or all the factual matrix that have been duly followed in the whole judgment itself. Only that particular operative portion is actually important. Then, Ganesh, next slide. These are all the example analysis of a real Indian case. Next slide, I think. Can we move on to the next slide? Next slide. How to read a 100-page judgment smartly. So these are the steps where to read head note. The head note is very much important because whenever we are reading or citing judgments to the court, the judge will not ask you to read about the section. He will ask you to find about the citations, why you are relying on such contention. So on finding of those judgments, it will make easier if we look into head note. That main particular operative portion or main contention of the case or the issue, primary issue, will be discussed in the short way passage in the judgment. That is called the head notes. So if we read on a glance way, that is the outer look way, on a slight way, you will be understanding that the judgment is based on the only particular one aspect that will be there in the shortly discussed in the head note. So if we see and read the head notes, you will come into conclusion, yes, this judgment is based on so and so concepts, on so and so article, so and so law, so and so section. Then read issues framed. Now the mistake mostly committed by the law interns is they will read the head note and they will read the operative portion, but they will not read facts because whole judgment will not be possible, or such patience will not be there for us. So if we read a glance look on the factual aspects that have been delivered in the judgment, that why this judgment that which I citing to the court is actually cited because my factual aspects and their factual aspects are same in nature. When this same in nature applied, then only that particular judgment will become precedent, that is binding on our contention. Then only the court will follow. Otherwise, they will not follow our judgments. Now, jumping to reason part, that is the operative portion. Now, identify the legal principle. Whenever such judgment has been delivered by the court, the main core principle will be definitely there. Either it will be discussed on one particular section or one particular concept or another particular issue or aspect. That main contention will be discussed on the judgment. Now, note paragraph numbers. So, whenever we are citing or we are reading the verbatim of the judgment, we need to initially start with the main contention that where we are relying. By starting over with that particular para and ending with our operative portion, we need to elaborately discuss it and submission to the court. Many people do mistake in this particular aspect itself. See, when I say you will definitely win a case, even if you don't have good citations or if you don't have good particular, or when you do not have any merits on your case, even then you will win the case only if you better do convincing to the court by taking your submissions or reaching it to the court. When we are in a position where we are arguing one case and where we are discussing another case aspects, it will become contrary to our own case itself. And it is also important. All of us, we need to remember, whenever we cite one judgment, it should not be been contravened. That is another similar case when the latest case has been given, which is contrary to this judgment. Only the latest judgments will be having the sanctity or authenticity power. If previously, suppose for example, in the same nature, two judgments are there. One is given in 2005 and another is on 2012. 2005 judgment has been something issued on one way, and the latest judgment, that is 2012 or 2010, is given on totally contrary to it. Then which judgment should be followed? And both are given by apex courts. So the latest judgment will be applied. The latest rule will be taken. Now, never read the judgment like a novel, because when we are reading the novel, of course, it differs from each one of us, one to one. But whenever we are reading the judgment, try to lead like an advocate. There should be some difference between advocates or lawyers or someone who have been knowledge on law and to when we compare to the others. Whenever we read the judgment, at least try to read the in between the lines, because most of the thing will be missing on that particular aspect itself. So in definitely reading those judgments of the operative portion will definitely comes the practical way of thinking that why the judgment have been become or called to be called as landmark judgment. What is the intention of that particular aspect that has been given in the form of judgment? If because at last, if the true tribute to the form of justice is called by the judgment form itself, not by any other means, you will get true justice by only the form of judgment. And that is why the judgment plays a vital role. Only the judgment gives you the justice. Only the judgment gives you a place where your deprived right is also can be still taken back and give you the form. So always try to read like a lawyer, like not barely reading. Try to understand the intention of the law, that yes, this particular aspect has been given in that particular form only because of only some particular relief itself. Like for example, there are some practical uh, procedures which are not followed or discussed in law books. Suppose for example, in a trial court, now we are going to the trial court issue. Petitioner witness, that is PW1, petitioner witness will be there and respondent RWs will be there. And sometimes the court also will be taken court witnesses, that is called CW. So when PW1 have been taken chief examination, that is examination in chief, we need to, the respondent counsel will be taking the cross examination. Now here what happened here is he missed the cross examination, which is PW1. Then PW2 examination has been happened, that is chief affidavit, chief examination have been made. Then PW3 chief examination has been made and cross examination also have been made. Then can we go to PW1 and ask the cross examination after all completing this PW2 and PW3? Can court allow PW1 to cross examine the PW1 examination in chief or chief examination? I say bluntly no, because these two aspects, PW2, PW3, have been taken examination in chief, that is chief examination. Their submissions have been given to the court. Now, the respondent counsel will try to mischief the PW1 by submitting PW2 and PW3 results, so that the cross examination will not happen. More than that, the misleading to the court will happen, and that reason itself, the courts will not entertain to further cross examine the person when the cross examination has rightly been conducted. This is the procedural way where the judgments are there. All those aspects which are not discussed in sections, by the form of interpretations, the judgments will be there, and the judgments will give you the answer how to follow these procedures, how to come into conclusion where such lapses or latches are there. So these judgments will definitely shape and carve our minds to follow in an authentic way, or to come into a conclusion where the errors have been made and where the cases have been filed and where to give the deprived person to get justice. So I think this will be the last slide, right? Ganesh, is there any next slide?
Yeah, I think there are 5 more slides.
Okay, we'll be shifting to the next slide.
Okay.
How to check if a case is good law or not? Like for example, it is overruled, referred, followed, distinguished. Now yes, it is also one important aspect, because previously I have been given one example where in 2005 Apex Court given one judgment, and that is recent latest case in year 2012. It is contrary to the 2005 judgment. Like for example, if you see the uh, principles of natural, that is the right to privacy case. Puttaswamy case gives you the right to privacy is protected, but before that it is not protected, and in between many case laws were there. Now which case law become landmark judgment? The Puttaswamy case, not the previous cases. Now for example, if I cited on that particular aspect the previous cases but not the Puttaswamy case, it is not correct way to submit it to the court, because a latest decision has been followed and a latest judgment has been delivered in that particular aspect. Now if I cite wrong submissions or wrong intakes or misleading the courts, it is overruled. Now when one particular has not been discussed, that is previously I have cited the word sub silent show, that is silent on such particular aspect, then that the particular legal submission will be referred to the higher bench, that is called referred. The courts will refer on one particular legal submission only, not on the whole contention. Whenever 3 benches judges, 5 bench judges, or the constitution bench, or 7 bench, or 13 bench will be taking one decision, they will intake on only on legal submissions, not on the factual matrix of the case. They do not have jurisdiction. The ultimate jurisdiction to decide on factual aspects is either a single bench or a double bench. I mean, it is in my opinion, in my way of understanding. Tomorrow it will change, or I don't know what exactly where the situation comes. But as per my knowledge, as per my source, only the legal submissions, only the legal concept, only the legal principles, interpretations only will be given by higher bench or larger bench. The only legal answers, submissions will be taken up by the triple bench or the constitution bench or the any such other larger bench. So this will refer, that is the single bench or the double bench will refer only on that particular legal aspect to the higher bench, not the whole case. Now it is followed or not. It is simply when the apex court judgment that has been delivered, that the same this court has been followed or not. That court have been given reasoning into that particular aspect or not, whether this decision has been followed by other high courts or not, whether that decision, whether still it is in following or not, because any some other new latest case law have been, if we intake find out, then this decision will be at stake. So whether that decision is followed, that is to be in reason. Suppose the judgment where the judge comes to picture and conclusion, the reasoning of the judgment will be there. In that reasoning, whether these case laws have been highlighted, whether that decision precedents have been followed by the apex court, still on it is on going or not, or it is still in dispute, we need to check. Then the distinguish, like the difference, when my contention, when my case, when my whole aspect of the contention of the law which I am going to submit my arguments, when my aspect itself is different, the which the precedents or the citations or the case law which I have submitted, even though they are allowed, even though they are binding, when the difference of my particular factual aspect and that particular citation that I have been submitted is different, then that is not binding on the court. Then it is overruled. Then it is not to be. It is called distinguished. Ganesh, next slide. Common mistakes by law students. This is one particular reality of the students where they'll be copying long paragraph, not reading full judgment, ignoring factual matrix, citing outdated law, that is not the recent ones. Next, confusing obiter with ratios. The main thing is the difference between obiter dicta and the ratio density we need to understand. The main principle, the main legal contention, the main core part, the heart and soul of the judgment is ratio decidendi. So where the pervasive findings, all the other aspects, all the other forms which not the main contention, but there are some other contention of the judgment. That is obiter dicta. I hope now the clarity has been widely, like whenever such courts interpret one judgment, there have been many issues, but there will be one primary issue. That primary issue is called ratio decidendi, why the court comes into picture and why the court gives the judgment. There will be some other small chota mota issues like for example, small and minor issues, factual aspects, other findings, that is called persuasive findings. All these comes under obiter dicta. Now next slide. Advanced research method. I see one way the each and everyone's opinion is different upon these advanced research method. Some will follow IRAC method, issue, rule, application, and conclusion. And some will follow issue-based research, comparative citation, cross jurisdiction analysis, law commission reports, legislative debates. Yes, we all need to follow all these things, but it is there, like for example, whenever we cite the judgments, whenever we cite something which the legal submission has been made by us in the court, we need to check the jurisdictional court first. Like for example, apex court decision will be followed from nook and corner of our country, and in every court will be binding. But suppose if I am practicing in one particular high court, that is for example AP High Court, after apex court, this high court judgments will become binding on that state. Then only the other, that is various high court judgments, will be followed. And it is not good to suggest that lower court judgment will be copy will not be given in submitted in apex court or any other high court. It is totally wrong. So whether International Court of Justice is there, ICAJ, that is there in Hague, whether that judgment can I cite in High Court or any other court in India or not. So this will become another question. Now, whenever we come or whenever such court, the International Court judgment is cited, more than that, the apex court judgment has been validity. It is more authenticated. Then the High Court judgment is authenticated. It is not good to suggest that these international court judgments, they do not have place at all. They have their own role and their own capacity and their own number, but only it is after the apex court judgment or that particular state high court judgment, then only comes into picture of citing the international court judgments. Next slide. Why judgment reading builds advocacy? Because it teaches legal reasoning, structural thinking, interpretation of statutes, constitutional philosophy, courtroom language. All these are in fact, I could definitely say, see, the difference between a senior advocate and a junior and an initial position is not on the section or the law books. The constitution is same for me and for all of you and for everyone who is not only residing in India, it will also applicable for those who are not residing in India also. That is the fundamental rights. So for when one book or one aspect, one thing is same for everyone, why there is a difference between you, me and the senior advocates and all those advocates who are dealing with these subjects? It is because their understanding of law, their maturity in law, their reasoning skills in law, their arguments, understanding analytical concepts in law, their way of presentation, their way of convincing into the courtroom differs from the senior, from junior like me, or from the initialers like you. So when we read those judgments, the best way to get an analytical research or application of mind, or the best way where you will understand the main core of the courtroom decorum and distinguish, is reading judgments. The section is same for everyone. Only the judgments will say where to use those section and where not to use those section. where it is necessity and where it is not necessary. So the legal reasoning is important to us. Whenever we read the judgments, it will not like, for example, of course, it will be not like a novel or like interesting, or it is not like section we are reading in bare acts. It is the interpretation of that particular section in a practical way, whether that particular section is followed in this court where the deprived of right is to be upheld or not, where the justice is to be delivered in this case or not, is derived only from following the judgments. You will understand those interpretations. For example, previously, I think one intern asked me, "Sir, we have been passed the law course, but still we are unable to understand the courtroom exchange, or we are not able to answer or what not able to practice in a very practical way in courtrooms is actually because of this understanding, because of this intellectuality in not able to follow the sections in an interpretation way, because courts comes under not by reading those sections but by interpretation those sections, that we are relying on our factual aspects upon where we have been fighting for justice, upon what we have been asking the relief from the courts. So the legal reasoning will definitely gives you an important logical mind, so that the sections will become smallest part and the conscience will be developing on you, so that the fair, the just, the equity, the good conscience, the interpretation of that statutes will be discussing all these aspects. That is, the just law will be followed. What law has to be followed and where it to be followed. And that particular part is only discussed in judgments. That is why understanding judgments are very much important. And structured thinking. See, if we read those judgments, and suppose when we are reading some judgments which are dealing upon central state issues, that judgments will definitely have reasoning. It is not simply that because I have stated. It is not the Sharma that stating to all of you that you should rely on me. We all are in common. It is because of the constitution, and that constitution have been certain again derived to many other acts, many other law books, and it is not only that other law books. It is because of those judgments that the concept have been used in where, when, and what. You should use a right section in a right way, in a right form, in a right manner, at a right place, because right place is also important. If you go and cite in a non-jurisdictional court, then your case will be dismissed. So right place is also important. Then the interpretation of statutes is actually, it is very common to say that the just law and unjust law, there will be some particular words which are definitely can't be say in a common law. It is very much important. Just, fair, equity.
Sir, your voice is muted. Sir, your voice is muted. Please unmute them.
Am I audible?
Yeah,
Yes.
no, audible, audible.
Yes, sir.
Yeah. So where actually, I mean, the last sentence, what, I mean, where you have heard me last? Should I continue that? Lastly, where you have heard my voice, I mean, what topic or which sentence?
Like,
Okay, we'll be continuing on the constitutional philosophy. Like any example, if you take one judgment, there is a constitutional journey of the judgment. If we see the amendment procedure, this has been a constitutional journey from where I see Golaknath case to IR Coelho case. in between Keswananda Bharati case, Indira Gandhi versus Rajnarayan case, and there are many case law that has been throughout journey, and that journey through by interpreting, changing in a dynamic form, coming into a conclusion by reasoning to the situation where the previous was there and right now it is different. So the constitutional journey that has been made, all through the journey, the judge comes into one mind, and that mind will be placed so that the conclusion will be taken on the constitutional philosophy way, where that philosophy has been given in the form of judgment. When we say that judgment is actually binds on us, it is not because of the apex court delivered, or it is because of that court or this court or any other high court. The constitutional principles that have been given, that have been followed, that have been given in a reasoning way, then that judgment is fine, is actually to be followed. That judgment is binding on us. Not every judgment will have that precedent to follow in every aspect. Only that precedent have will aspect that will become landmark judgments. Not every judgment is a landmark judgment, and not every landmark judgment is permanent. We all need to remember, not every judgment is a landmark judgment, and not every landmark judgment is permanent. Now, the final takeaway is a good lawyer reads, okay, that is a one quotation. A good lawyer reads judgment. A great lawyer understands reasoning. An excellent lawyer applies precedent strategically. So this one particularly highlights where some reads good judgments to get that understanding the core principles or the main era or aura of law, the soul of law. A great lawyer is one who understands that maturity will develop. There is a difference between my argument and the senior advocate argument. So an excellent lawyer applies the precedent strategically. It is always remember one thing. In the lamps of judiciary, we'll say one word, that is wit, W-I-T. It is important to everyone. Whenever we are arguing, it is not to say that the best way he is argued or the correct he argued. It is the thing that how he argued. It is only the thing how he conveyed the judge. Convincing is more important than your president, than my contention. Because if you able to convince the judge by submitting your judgments or by interpretation of those statutes or interpretation of laws, then there is a high chance that not you followed the judgment that you have been binding on. You have created the judgment. You make your judgment a landmark judgment. So whenever such contentions are sub-silent show, it is a high chance that this judgment will become a landmark judgment on that particular topic. So try to focus on judgments so that you will understand, and then you will make and recreate your own judgments in your own name. Now, mostly the topic has been finished. If you want, we can discuss again elaborately. Since time constraint, I think the questionnaires, if at all any questions have been there or you want to ask on any aspect, you can. I think the host will be. I think Raghu or someone is the host. Hello.
Yeah, sir. Thank you, sir.
Yeah. Is there any questionnaire?
No, sir.
No. Okay. So I think I have raised one doubt, right? Whether it is the court that gives judgment or the judge gives the judgment. So probably, in my opinion, the court is only authorized to give judgment, and the judge is one part of the court. Like the stenographer will be there, where the petition counsel will be there, the respondent counsel will be there, and all these put together in one form in one particular place. Then it will become the court. Whether but the court will comes easier to give the judgment by the help of judge conscience. So the judge conscience plays a vital role. If I am not there, or if the respondent is not there, even the stenographer is not there, it is okay to the court. But if the judge is not there, then it is not to be say that like if judge is not there, it is not to be called as court. So judge itself is not court, but where the judge is there, it will becomes a court. So if we see the judgment, it is the good conscience of the court that the court believed on that particular argument that have been cited by us. So it is actually the role of the particular petitioner and respondent, and by the submissions that the judge consents, the judgment is delivered by the court. So all of us have a role on this, and that is why the judgment will be delivered by the court. That means all of us. So I think the answer is that, on my opinion. And by this, we'll be ending our session. And thank you for giving me the opportunity.
Thank you, sir, for the detailed and practical explanation. It was truly insightful and beneficial for all of us. Yeah. On behalf of SVLS, I sincerely thank you and for sharing your valuable time and practical knowledge with all of us, and all the interns for attending this session actively and maintaining discipline. And a very huge thanks to our organizing team members for coordinating this program successfully. So we have recorded the whole session for interns. You can review it once again. And those who are not present can check it in the WhatsApp group. Yeah. And one more thing, SVLS is also present in Tamil Nadu and Telangana also. If anyone is interested in joining, please contact us through the SVLS Instagram page after the session. Yes, sir. Thank you, sir. Thank you, everyone.
Thank you so much.
Yeah, I'm, very, I'm very much happy, and as well as I'm very much thankful to the SVLS AP chapter team, and they are doing very well by giving these internship programs to I think almost to all over India. You have placed your intern opportunities, right? I'm finding multiple students from various places, not on any single state or not. Are they belong to one particular state, or there are multiple from regions they have been placed? You have given internship
Multiple
opportunities.
interns from various universities, sir.
Yeah, I find yes, they are very good, and they have been really taking very good initiative, and we need to give much appreciation to your efforts. So I can give you one small recommendation to this AP chapter. If you find anyone from this internship program, or anyone to have one good internship in our AP High Court, so I'll give you that opportunity. A paid internship will be given from my side, and if you want that and to be placed in High Court also, anything from High Court, you can simply take my suggestion, or you can ask me from my side. So I will be giving this opportunity to one of those candidates who will be recommended from SVLS. And thank you for the opportunity.
Thank you so much, Anna.
Thank you, sir. And I can say that the topics are closely connected to real world and legal issues, making the session practically and meaningful. Thank you so much for this.
Thank you, sir.
Yeah, thank you,
Okay.
everyone. Now the session ends. Is there any?
If all thank yous are completed, I can leave from this session.
Yes, sir, you can leave.
Okay, thank you.
Thank you so much, sir.